Hi there, I'm Jonathan Ginsberg. I'm a Social Security disability attorney, and today I'd like to answer a question I got from one of my YouTube viewers. And the gist of it is this. Anybody can tell that I'm disabled just by looking at me. What else does the judge need? And what this person is getting at is that they feel like that just by looking at that person, it's pretty obvious they are disabled. And it's just upsetting to this person that they were denied by Social Security, they had to file an appeal, they're denied there. Now they go to a hearing and they don't get a good sense of what's going on at the hearing. What does the judge need when it's really obvious that you are disabled? Well, the answer is pretty simple, and that's evidence. You have to understand that even though you may know that you're disabled, you may have a completely good faith belief that you don't have the capacity for work anymore, you live with yourself 24/7. The judge has met you for the first time and will spend maybe 45 minutes with you. The judge does not know what your life is like, what you go through. Even if you tell the judge that, he or she is taking testimony from you about your own situation. Obviously, that testimony is biased because you live it. So what the judge is looking for is evidence. So what that means is even if you have a completely, totally obvious situation where you're disabled, you've tried to work, you simply can't do that, but you can't afford to go to the doctor, there's no MRI evidence, there's no CT evidence, there's no ultrasound or nerve conduction study, nothing like that, then all the judge is going to have is your testimony that in fact you can't do X, Y, and Z. Well, the judge hears that testimony from claimants every day, 4 or 5 times a day, 3 or 4 days a week. So you're not going to get approved simply by telling the judge that, yes, I know I'm disabled. And unless you have a situation where you have an amputated limb or you have clearly have some form of cancer that is very obvious that a judge can see, a judge is not going to accept what you say. You've got to have evidence. And in fact, there's case law out there that basically says that a judge is not allowed to use what they call sit and squirm jurisprudence or judging to make a decision. The judge is not supposed to deny you because you look healthy. By the same token, the judge is not supposed to approve you because you look really sick. So you've got to have evidence in your file, and don't make the mistake of believing that because you have lived with this and you are convinced that you are disabled that you're going to win. In fact, one of the issues that I run into sometimes is people have what I would call an attitude of entitlement. They believe they know they're disabled, they believe it with all their heart, and so the judge picks up on the fact that maybe you've given up or that you believe you're disabled, and that is a negative. The judge is going to look at that and say, well, this person is really not trying to fight being disabled. This person's not trying to fight to go back to work. So no matter what you believe in your heart of hearts, realize that for this judge, who's a third party, supposed to be neutral, sometimes bordering on cynical, I think that you've got to have really strong evidence. So that's why you've got to enlist the help of your doctors to discuss the work limitations you may have. You've got to have objective tests if those are possible. Again, things like an MRI or a CT, treatment from a specialist, one or more specialists. So you're trying to paint a picture in a hearing for the judge to understand why you're not able to work. So the why is really important. And again, you've got to paint the picture. That's your attorney's obligation is to paint that picture. But simply going in and saying, I know I'm disabled, pay me, is just not going to work. And I don't know that it ever really worked, but it certainly does not work at this point in time. Hope you found this helpful. If you did, please give it a thumbs up on YouTube, like it on Facebook, leave me a comment, let me know what you think. Do you think that you were treated unfairly because the judge maybe looked at you and thought you looked healthy, or that you possibly could work even though the evidence said otherwise? Or what do you think about my argument here that you've got to have evidence, and how unfair might it be if you don't have the money to pay for that evidence? But anyway, let me know what you think in the comments. If you've not already done so, go to my website at ssdanswers.com. You can download my free Secrets to Winning Disability Survival Kit. It's delivered by email. I think I'm up to 35 or 36 installments there. So it's a lot of great information. And if you're not already represented, you'd like a case evaluation, you can do that at SSD Answers as well. So for now, this is Jonathan Ginsberg wishing you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit. that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.